Appreciate the opportunity to come out this morning. Tell everybody I'm not a morning person, so if this is a little flat and a little white, the question will speak is definitely in the morning. Get a little bit better after lunch and get cleaned up around then. But I appreciate the invitation. We're going to
higher some up your mouth a little bit better so we can hear you.
Okay, can you hear me now? Can you hear me now? Okay, sorry about that. If you're not familiar with the real estate center, that's my boss. We're on the A&M campus, but we are not a state agency. We don't get any state money. We are entirely supported by the real estate industry. Whenever a real estate agent renews a license, gets a new license, part of that funds comes to us. We were established 40 years ago by statute, placing us on the A&M campus. Our legislative directive, and this is important, y'all remember this, is to research issues affecting real estate and to give those results back to the real estate industry and to the general public. And we do this primarily through our publications, but also through speeches like this. But when I'm given the opportunity to write, and I have to write, at least 4 or 5 articles a year, I like to write about property rights. I like to tell property owners exactly when you own property, exactly what rights do you own. And more importantly, if you own those rights, how to best utilize and protect them. And over time, I've come up with a bunch of articles, which may or may not be of interest to y'all. But here's just kind of a bunch of how-tos. How to negotiate oil and gas leaks. There's a lot of development in this area, obviously, a lot of deep gas, XTO, majors are in this country. Do you know what a producer's 88 says? The lease form they give you called producer's 88. Do you understand exactly what it says? Do you understand the legal implications if you sign this without making changes? This article goes through producer's 88, it tells you what it means, and tells you more importantly what you need to change for your benefit. And if you don't change it before you sign it, it's over. So it's best you better read an article and understand what you're signing before you get into this transaction. Believe it or not, I want to plant it. An oil and gas lease has the word lease on the end of it. Is it actually a rental agreement or is it a deed conveyance? When you sign an oil and gas lease, are you signing a lease or are you deeding your property? You're deeding your property. An oil and gas lease is a deed. It's a mineral deed. So I tell a lot of people, like, well, it's just a lease. No, it's a deed. It's a deed for so long as they produce your property. It ends when the lease ends and it reverts back to you, but you're actually deeding a right-of-way. So most important, you understand this is a very critical instrument. You understand what you're getting into. Water. Talk about water. This seems to be a water convention so far. If you're approached for a water lease, do you know what to negotiate? So we got hints on negotiating oil and gas lease, hints on negotiating a water lease, wind rights and wrongs, believe it or not, how to negotiate a wind lease. I'm trying to stay abreast of what's needed in Texas, and in West Texas, there is no information telling landowners what they need to negotiate in wind leases. So if you need to negotiate a wind lease, we have a publication. Texas easements. Can you own landlocked land in Texas? Can you own land that has no public or private access? You damn betcha you can. So don't think just because you own property, you have an automatic right to access it. Now, what runs into problems, I'm going to hit real quickly. There are 2 types of easements. There's an easement that attaches to the land. Whenever you own a piece of land, you automatically have a right to use an easement. It's called an impersonal easement. But there's another type of easement called a personal easement. And a lot of your easements arise personally. My granddad needed to cross land on your granddaddy to get to some grazing land. And back then, quote back then, all you had to do was ask permission. Sure, you can come in, cross my land. And that is an easement, but it attaches to a person, not to the land. And a personal easement is called an engrossed easement, can be terminated unilaterally at any time by the landowner. And what you have today is people coming into Limestone County from Houston or Dallas and buying land, and they want exclusivity. And if they see somebody crossing their land, and they say, I bought a title policy, nothing says that you have an easement, because this is a personal easement, and they'll cut you off. They start locking those gates. And I get a question daily from a landowner or from an attorney asking about easements. It is critical, because Texas becomes chopped up as the population grows. We're dividing this land, and easement becomes, and access becomes more and more critical. I just put this out to you. You can get the land, even though you don't have a deeded easement under an implied easement. And this publication goes into all the details of how private and public easements arise and how they are terminated. The Texas Deer Lease publication we're going to talk about today, the first part of it, if you're a landowner, has a checklist of all the things you need to negotiate in a deer lease. If you're leasing, if you're the hunter, you're the landowner, here's a checklist for you to go through. And am I covering all these problems or all these situations? If I'm not, I may have a problem on hand later on. Gentlemen, asked me a while ago, if you sign a deer lease or grant somebody a deer lease, if you're the landowner, does that give you the right to continue to hunt on your land or not? Or does it give the hunter the exclusive right only to hunt on that land? It's an issue you better discuss when you do a deer lease. Heard earlier about the politician, Cook. Condemnation is probably the most intrusive process on property rights there is in Texas. The most unwelcome, intrusive invasion of property rights in Texas. And the last two sessions the Texas legislature has tried with Fambrough, Texas Wildlife Association, has tried to change the process. It is grossly unfair to landowners. So if you are contacted, how many of you have a pipeline on your property? I'll put my hand up too. And that pipeline was taken in lieu of either by condemnation or in lieu of condemnation. Now I'll throw this out to you. When does a pipeline easement end? You that have a pipeline on your property, when will that easement terminate? It will terminate when they abandon it. And abandonment is not what you think it is. Abandonment is defined as when they quit using it, objective, with the intent never to use it again, subjective. And we've had a case in Texas where a railroad easement, they took up the tracks, hadn't used it for 20 years, and the tracks have been removed, and the landowner started taking that material off those beds to make roads with it, and the railroad comes in and gets an injunction against the landowners. And they said, hell, you quit using it, and you abandoned it 20 years ago. And they said, no, we quit using it 20 years ago, but we intend to come back and use it again. After 20 years, the court said, well, if they intend to come back, it's still in force. So it's when they quit using it with the intent never to use it again. If you are approached for a condemnation of the pipeline, you better, in fact, the gentleman called me yesterday. He said, I heard you talk about this, they approaching me, I need that information. You better get this publication if you're approached for pipeline easement. It talks about the condemnation process, but more importantly, it talks about the things you need to negotiate in that easement for your protection. And one of the things you put in here, if you go 6 months of non-continuous use with that pipeline, this damn thing terminates. Non-use for 6 continuous months means this lease, this easement is over. If you don't put it in there, you're back to that abandonment standard. Another, how many lines are you going to put in? More importantly, why can you move through that line? If you read that document, it gives them the right to put through that line oil, gas, water, inert material, anything, dead bodies if they can go through there. Anything that's possible to shove through that line, they have a right to put it in there according to that easement agreement. You limit it to natural gas. If you don't limit to natural gas, they have the right to put those other products through there. Now you may not, it's all right to put other products through there. But what I'm getting at is this, if you limit it to natural gas, which that's the reason they're taking the pipeline, then if they want to put oil through it later on, guess what? They have to come back and get another easement from it. If they want to come back and put water through it, what do they got to do? They got to get another easement from it. So you protect those property rights. That's what I'm doing with all of these articles. You protect your property rights. One on the bottom, negotiating transmission line easements. That's where I'm going now more than anywhere else in Texas. Right now, we can generate with wind power 8,000 megawatts of electricity. Present capacity of the wires in Texas, out of West Texas, can only move 4,500 megawatts. There's a 3,500 megawatt deficit in being able to move electricity out of West Texas off those wind turbines. So now they're condemning transmission lines. And I went out and looked, there is no information to landowner for them to understand the condemnation process involved in transmission line. More importantly, what they need to negotiate in those lines. There's a big difference between an exclusive and a non-exclusive easement. And you better make sure it's non-exclusive because they'll ask for an exclusive one. And I've just gone through there just a multitude of things that landowners need to negotiate and understand to protect their property rights, in that sense, just condemnation of transmission lines. I've been out giving talks, and you know what? One of the main condemnors is LCRA, Lower Colorado River Authority. I gave a talk in Fredericksburg, and the attorneys are sending me letters saying I'm misleading the public, and they want me to stop giving those talks. Why? Because I'm telling landowners what their rights are and what they need to do, and LCRA is trying to shut me up. You're out here on the line, you get shot at. I'm getting shot at. I'm not backing down. And I'm going to win on that one. But I'm just telling you, if you're out here trying to dump people with private rights, the people that are taking advantage of you will try to stop me. Anybody else do it. Another one, if you want to understand, get your real estate license, there's another one. But there's all kinds. I have over 150 articles online. So if you want those or anything else, I can figure this out. Correct. Go to our website. Everything we have over 900 articles on Texas real estate free off our website. Yeah, used to this thing works. Am I doing something wrong? I think I'd go down there and anyway, if you want to go to our website, recenter.tamu.edu, that's where we have a host of information. If you want to get any of the publications I just talked about or anything else, get this to work, go up here to publications. It's got our website. Second is publications. Click on publications. I'm just not going to give you the website, but you have to get our publications. Click on publication where you hit publication where you see headline news, wait a couple of seconds, it turns to topics. All of our articles are listed under about 20 topics. Like if you want to go to condemnation, go to the C's. If you'll go to easements, go down to ease and click on easement. Now everything I was talking about earlier is under L leasing. Go down to L, click on leasing, and then everything on the right comes up. You just click on the article you want. Now the Texas Deer Lease that you have in your publication, if you ever want to download an extra copy of that, I'm going to tell you, it says add to cart, which means like they want you to buy it. But I told you everything was free. Just click on that, you'll see the publication. They have a picture of the front page. If you just click on that front page, it gives it to you free, or you can add a cart. Aggies always say add a cart, but I hope you'll just click on the side of the picture there and it's free too. So again, we have, if you go over to resources, data, we have all the land data in Texas. If you want to look on region, we'll have the land prices or the region you can do so. So there's a host of information here. We do have a spreadsheet that you can see over on the right, which hopefully y'all take advantage of. I'm sorry. We're going to talk about that today. Yes, ma'am. You can find one in your publication some Texas deer lists. Hopefully we'll get to that this morning.
I mean, it didn't concern the deer list, just for.
No, this is for anything. Not just for deer lists. My name is Judon, and people ask me, is that a family name? No, I was born in Pumpkin Center, Texas. Pumpkin Center is on South Plains, north of Lamesa and south of Lubbock. When I was born, there was a Baptist preacher holding a revival there named Judon Cobb. And my parents took that name Judon and put it on my birth certificate, so I have been named after a Baptist preacher. So if I start quoting scripture this morning, I have a license to do so, okay? Well, the bottom line is, and that's what I want to come into. I just want you to know there's a lot of things about property rights that you want to try to understand and protect. Hopefully I've got an article out there that will help you out. But one of the things that you've got to think about, if you're going to diversify your ranching or farming operation, one of the things that you're going to think about is letting people come onto your property. Traditionally, we've always had deer hunting. One of the things they're going through now is nature tourism. I think Miles Phillips is going to talk about nature tourism. One of the concepts, and y'all are in a great place. You're here between Dallas and Houston. You're on close to I-45. People want to take a weekend off and come out and just enjoy nature. It's a non-consumptive use of your property. They just want to see, they want to see the moon at night because there's lights. They want to see a sunset. And if you have a cabin, maybe that you're just letting hunters use during the hunting season, you can use that during the summer. People want to come out and enjoy nature. But if you let people on your property, it's got to be a light bulb in the back of your head. Am I risking the farm? If somebody gets hurt and I get sued, I'm in jeopardy of losing everything because I just want a few extra dollars. That's got to be something. The benefits outweigh the risk, or the risk outweigh the benefits when it comes to letting people off to gain some extra amount of money. And I will tell you right now, based on the statutes in Texas, the benefits outweigh the risk. And I hope I'll explain that to them. The benefits outweigh the risk in Texas. Why? Because 97% of Texas is privately owned. And the only way they can get, the legislature can get private land open to the public is to reduce the landowner's liability. And there's none other in Chapter 75 of the recreational gas statute that we will talk about this morning. So, let's talk about this risk. What duties do you owe to people on your property? Well, I'm going to tell you, it's real easy to tell you what your duty is if you can tell me or explain to me what their legal classification is at the time of the injury. Landowner liability is based on legal classification of the person injured. And once you know their legal classification, then you can determine whether you met your requirements or not. But overall, there are 4 ways to limit your liability to people on your property. Meet your common law duties, which we will talk about. Meet your statutory duties, which in Chapter 75 is it changes the common law to some degree. Talk about earn a secure waivers from your hunting to the people and guests coming on your property, and also give them assumption of risk for gross negligence. So we're going to talk about over these four topics in the time I have. Common law, this is where it all starts. Common law is a law developed by our court system. It's not the law given a statute, it's developed by court decisions based on fact situations. And under the common law, there are 4 legal classifications of people that can be on your land. There's only 4 possible classifications. So we're going to go through those 4, and then we're going to look how the Chapter 75 has changed that to some degree. So first of all, the highest degree of care that you can owe to anybody are called invitees. Invitees are people who are paying to be on your property. These are the people that are your hunters that are paying to be there. These are your nature tourists that are coming to pay to be on your land. This is where your revenue is coming from. The good news is they're paying to be there. The bad news is the highest degree of liability that you can have is to an invitee. Now, what is your duty? Invitee, somebody paying to be on your land. What is your duty? You have to warn or make safe. Warn or make safe all the dangerous conditions you know about or you should know about. Sometimes the law says it's all you have to warn or make safe all the dangerous conditions you know about or a reasonable inspection would reveal. And the longer you have a dangerous condition on your property, the more the courts will find that you should have known about it. So if you have hunters coming, basically you have to go out, check all the blinds, check all the lodges, make sure everything is safe, and if it's not, either make it safe or warn your hunters. This is in advance of their being there. Nature tour, the same thing. Warn or make safe all the dangerous conditions you know about or you should know about. This degree of care is not limited to rural landowners. If you walk into the Walmart or an H-E-B, you are an invitee of that establishment. And have you ever noticed where they have the kind of fold-out sign that says "Beware of foreign substance" on the wall, on the floor, or something? You know, they fold out all this. They are warning, meeting their common law duty, warning until they have a chance to make it safe. So it's across the board to everyone. That's the bad news. You want to hear the good news? You do not ensure the safety of an invitee. You have to do the warn or make safe, but you don't guarantee their safety. Common law says that an invitee has a duty to be on the lookout for an open and obvious dangerous condition and avoid it. You have a duty to warn or make safe, they have a duty to avoid an open and obvious dangerous condition. If there is an incident, comparative negligence is the rule of Texas. Comparative negligence. Let's say a little lady is walking down the H-E-B aisle next to the frozen food section and there's condensates on the floor. And she slips and falls and breaks her leg and had $10,000 of medical damages. Medical charge. She's going to say, "You failed to warn me. You didn't put out the little sign to say beware of foreign substance on the floor." H-E-B is going to say, "Yeah, we didn't have it out there, we didn't know about it, but you had to be on the lookout and look and avoid that condensation that was there." Comparative negligence. The courts will then decide based on a percentage, what percentage responsibility is the little lady and what percentage responsibility is H-E-B for that accident. Now follow me. If they find the little lady 30% responsible and H-E-B 70% responsible, then the lady will recover, but the recovery will be diminished by 30% to the degree she contributed toward her own injury. So in this case, her recovery would be $7,000. Comparative negligence. How responsible is the plaintiff? How responsible is the defendant? If the jury or judge finds that the lady was 51% responsible and H-E-B was 49%, how much is the recovery? Zero. Because the plaintiff is more responsible than the defendant, 51, 49%, 51% plaintiff, 49% defendant, no recovery. So we have comparative negligence, which is good in Texas. You have to agree to warn or make safe, they have to be on the lookout. Comparative negligence will eventually settle the amount. The next one down on the list are licensees. Invitees are paying to be there. Licensees are not paying to be there, but they have a right. These are your social guests. These are people that you invite over for dinner Sunday afternoon. They have a right. They are invited to be there, but they're not paying to be there. The difference between having $1 million and $1 billion friends, or you having invitees over, or you having licensees over. You having invitees over, hopefully you're a millionaire because they're paying. Licensees, hope you got $1 million friends because they're not paying to be there. Same type of degree of care. You have a duty to warn or make safe all the dangerous conditions you know about. No inspection, no should have known. If you know of a dangerous condition, you either warn or make safe to your licensee. If you're asking me to come out and go fishing, and you know you've got a weak board down on one of your piers, tell me about it. Tell me about it and I get hurt, you're off the hook. But again, comparative negligence. A licensee has a duty to be on the lookout for an open and obvious dangerous condition. So if I still step on that board and you fail to warn me, comparative negligence still establishes whether or how much I would recover. Percentages. How responsible were you for not warning? How responsible was I for not being observant? Now, this question always comes up. Warn or make safe all the dangerous conditions you know about. Would you have to warn about the presence of rattlesnakes, copperheads? Y'all got the coral snakes in this area, right? What about the wild hogs? What about bull-nettled plants? Do you have a duty to warn about natural conditions? Or is this just the artificial man-made conditions that are on your property? Well, the Texas Supreme Court, and I always tell her, I'm writing an excellent article right now on this topic because the Texas Supreme Court has taken it up. Here's what happened, let y'all be the judge and juror. These people go to Garner State Park, which is down by Uvalde. They pay to be there, so they're invitees. They're sitting at a picnic table under a live oak tree, and guess what? For no reason at all, one of the limbs breaks out of the trees, falls down, and hits the lady on the head. And they sue the state of Texas for failing to warn. I'm just saying, this is a natural condition, just like rattlesnakes is a natural condition. Do you have a duty to warn or make safe? That's a big question law. We do have one case that came out of San Antonio, and here's what happened. It was at Choke Canyon, Three Rivers Choke Canyon down by Corpus. They had some snowbirds. You know what a snowbird is, right? As the people drive down from Illinois at the beginning of in the fall, beginning of the winter, Airstream trailer, and they check into a KOA seasonal camping. Wasn't sure, but the lady said, I told them, and watch out for the fire ants. But they weren't really sure about the fire ants. But anyway, the gentleman gets his space, parks his Airstream, and the first thing you do, I don't know what, is you level them up, you know, for the winter. You want a level place to live. He obviously rolls through a fire ant because that's the issue in the case. And they sting him. Well, obviously it hurts. We've all been stung. But this gentleman is allergic. He goes in shock and dies 2 weeks later from fire ant bite. The widow sues for wrongful death for failing to warn about fire ants. Kind of like the rattlesnake, okay? It goes up on appeal, and the judge rules correctly for the wrong reason. He says this, and this is the law of Texas, the best I can tell. A landowner has no duty to warn of the presence of a dangerous indigenous species of wildlife in its natural habitat. Say that again. You have no duty to warn about the presence of a dangerous indigenous species of wildlife in its natural habitat, which means you would have no duty to warn about rattlesnake. What was wrong with that opinion? Fire ants are not indigenous. So what are we going to do with that opinion, right? But I think that is the rule, and that's the rule they almost take away from not liable in this situation. But they didn't take up about the indigenous species. So you do not have duty to warn. Best I can tell. Now you should, if you know that rattlesnakes are copperheaded out there. But if they get bit, I don't think, or get whether stunk and whatever it has to be, I think it's pretty well, as long as it's in its natural habitat. If you got to have a rattlesnake in your house, they get bit, that's a different story. It has to be in its natural habitat. Well, but the big question is about what the natural is, and that's where the case law is going. And the question is about the trees. Texas Supreme Court, and I just finished up this article, they say you don't have to warn about a natural condition, dangerous condition. And they say you don't have to, and it says in that opinion, you don't have to worry about rattlesnakes or warning about panthers that goes with all that stuff. But it says this opinion, we are not telling you when a natural condition is so augmented by man that it is no longer natural but man-made. In other words, when you bring a rattlesnake into your house out of its natural habitat, you still have to warn. And the thing about the tree, now it's all about the tree. Would it make a difference if the tree is there naturally or if it was transplanted? So we've got a whole lot of case law to go before we really know about what is a natural condition. If somebody drowns in a pond, would it make a difference between that pond that's man-made and whether it was a natural occurring lake like Cali Lake? One man-made, one was natural. Would that make a difference? We don't know. The Texas Supreme Court has said we're going to leave that to the future. So what is a natural occurring object is going to be, and when it becomes a chain of man, something to be looked at in the future. All right, next category. Third, trespassers. Invitees, licensees, trespassers. What duty do you owe a trespasser? You have to avoid injuring them intentionally, maliciously, or through gross negligence. If you injure them through your negligence, no liability. But if you're grossly negligent, intentional conduct, or malicious conduct involved, you would be liable. Now, here's what I always throw everybody in. Well, let's all tell me what the law is. How can you impart notice of no trespassing in Texas so that if someone violates that notice, they can be charged with criminal trespass under 30.05 of the Texas Penal Code? What are the 5 ways that you can impart notice on your property of no trespassing? It's what?
You have to have it posted.
I'm sorry?
You have to have it posted.
Oh, posted. A no trespassing sign. Yes, ma'am, that is correct. How often do you have to post it, and what languages do you have to put it in? There is no frequency requirement. It just has to be posted to come to the attention of somebody entering the property. That's all the law says. It has to be posted. It has to be in English as far as I can tell. That's the only language. So no trespassing sign is one.
Just one sign.
What?
You don't get just one sign for that.
Well, I guess it depends on where they're entering. It depends on how much frontage you have, I think, more than anything else. It says it has to be opposite to come to the attention of anybody coming onto your property. That's pretty open.
Purple sign. Purple paint.
Purple paint. Purple paint. Everybody says purple paint, purple paint, purple paint. But I want you to tell me now, how high, what can you put it on? Only on a post or a tree, a rock or a chimney. Post or a tree, that's good. Now the second part, how high off the ground does it have to be? It's in my publication between 3 and 5 foot. On a post or tree, 3 to 5 foot above the ground. What are the dimensions of the mark? That paint has to be 3 to 5 foot above the ground. It has to be a minimum of 1 inch wide and 8 inches long. Vertical stripe, 1 by 8 minimum. How often do you have to post it? On a tree or on a post? Open area every 1,000 foot. In a forested area every 100 foot. So purple paints do work, but remember there's a lot more requirements. Only on post or tree. 3 to 5 foot above the ground. 1 by 8 and every 100 or 1,000 foot. So that's 2. You've got 3 to go. That's Texas law. It's in that publication. Let me throw you another one. If you ask somebody or tell either in writing or orally to leave your property or not to come onto your property and they disobey it, that's criminal trespass. Tell them not to come or tell them to leave. Now the next 2, a little bit different. How many of you are ranchers? How many run cattle? How many of you have no trespassing sign? Trick question. Any fence obviously designed to contain livestock is a no trespassing sign. Any fence obviously designed to contain livestock is a no trespassing in and of itself. So if you catch somebody out there on your property and you say you're trespassing, no, I didn't see any sign, I didn't see the rip the seat of your pants, you just went through it. A fence, apparently, obviously designed to contain livestock is no trespassing. Now, I always throw this one out, what about a high fence? What about a deer-proof fence? Is that designed to contain livestock or designed to contain deer? I don't know. I'm just throwing it out. I don't know the answer to that one. But there's still 1 more to go. This is in South Texas. The valley, not south of the valley. Any crop grown for human consumption in the process of being planted, cultivated, or harvested is a no trespassing sign. I went to the valley one time with a guy who used to live there, the banker. And on the way down, he said, you know, when they start harvesting the vegetables, the farmers really get antsy because all the people come in and start picking up the vegetables. I said, why? He said, because Texas, I think he said, is a garner jurisdiction. I can't remember what he's talking about. And he said, Texas subscribes to the Old Testament. You remember Ruth and Boaz, where they're supposed to leave 10% or something of the crops in the corner, you know, for people to come in. He says, Texas subscribes to that. The leader's law is what he said. Man, I don't know about that. I've never heard that. So I went back and went through all my books and couldn't find anything. So I got to 30.05 of the Texas Penal Codes that says that any crop grown for human consumption in and of itself a no trespassing sign. So Texas is not a cleaner's jurisdiction. It's opposite of the Old Testament. Okay. First biblical question. Why did they call Boaz before he got married? Happy, lucky, rich, or ruthless? Ruthless. You're only ruthless. Keep going. Number 5, no trespassing. Word for trespassing. If you injure them through your gross negligence, intentional conduct, and malicious conduct, you will be liable. It's important you remember that later on. The last one is trespassing children are the attractive nuisance doctrine. And this is a bad one for landowners. If you're maintaining a dangerous condition, man-made, at a place you know children are apt to trespass, down by the old swimming hole, and you are not achieving any economic benefit by maintaining that dangerous condition, the old swing that swings out over the water versus the risk of harm to children, and if a child gets hurt, you're liable. You must make it safe. There's no other way. Now children, let me tell you a little bit about children. A child takes on the legal classification of the adult they're with. A child takes on the legal classification of the adult they're with. So there is going to be an invitee, a licensee, or a trespasser. But if a child is not accompanied by an adult, and they're trespassing on your property, a place you know they're having to trespass and be told test, you're going to be liable. And there is no other way. And if you have a nature tourism or you have hunters, you might want to think about, am I going to let minors come in? Because your liability to minors is the highest degree. It's even above an invitee. There's no warn or make safe. If they get hurt, you're liable. Now, here's what happened. Here's what happened that set precedents here. It was the case 1963 that Van Eden in the Texas Supreme Court. What happened? Van Eden was a rancher in South Texas. And he, like in South Texas, provided housing for his employees. You know, all of the ranch hands lived on the ranch. Well, about 100 yards from where the ranch hands were housed was an abandoned dipping bed. Now, Van Eden had a religious experience. He went from being a Baptist to a Methodist. He quit dipping his cattle and started spraying them. This is a joke. He quit dipping his cattle, yeah, because, you know, technology is spraying. But he didn't cover the dipping bed. And he knew those children went out there and played around that dipping bed full of water. And one of them falls in and drowns, and he gets successfully sued under the attractive nuisance doctrine because he was maintaining a dangerous condition at a place he knew children were apt to trespass, and the economic benefit he would derive from that abandoned dipping vat was basically zero because he was spraying his cattle. And they go to court and they said $30, 30 minutes of work and $30 of dirt, you could have cured the whole situation. And when the jury hears that, the rancher gets hung on it. So, attractive nuisance doctrine. A child between 1 and 7, what they get hurt, get happy. Between 7 and about 14 or 16, it goes on a child-by-child basis. Did the child really go into dangerous or not? And then they just kind of went ahead and did it. And after 16, then they become an adult. But that's kind of the way that breaks out.
Well, there's an actual creek, the kids are going in,
That's for that. I've got an article on it, but you get into a lot of debates on, you know, did they really know it was dangerous or not? Did they pick up a snake, whatever. Well, the problem is a lot of kids like to trespass anyway, you know, and so they're out there on your property and they get hurt. You might be liable just because of tractor nuisance stuff. But they're trust really good. I agree. Well, let me tell you, come on. That's the bad news. There. The common law puts you into 4 categories. Texas statutory law said, listen, we need to change the common law. They passed Chapter 75 of the Texas Civil Practice and Remedies Code, and this is what I told you important to remember about trespassing. They said if you have people on your property for recreational purposes, some other qualifications we'll get into, then the duty you owe these people, whether they are invitees or licensees, whether these people are paying to be there or not, the duty you owe to recreational guests in Texas across the board is no greater than what you owe a trespasser. In other words, those categories of invitees and licensees vanishes. They go away when you have recreational guests on your property, and the duty you owe to a recreational guest according to the statute is the same duty you owe to a trespasser. You have to refrain from injuring them through gross negligence, intentional conduct, or maliciously. So, let's get into that a little bit. That's kind of the overview. By complying with this statute, 1, no greater duty on trespasser. 2, you don't assume or any liability that's safe for recreational purposes. And last of all, you assume no liability for the injuries or damage caused by the guests or customers to each other. And I call it the Dick Cheney syndrome. I'm going to read this here. Bill, interested in doing a little quail hunting next weekend? Bring the wife. When Cheney shot that attorney down on the Armstrong Ranch in South Texas, my phone rang one morning, and this woman said, I'm an MSNBC news program, and said, we understand you know something about Texas real estate law. I said, no, you got the wrong damn number. Because, you don't want to talk to them. You don't want to talk to people. But she said, this little lady, she said, we're looking under Texas law, what liability does Catherine Armstrong owe to the attorney that Dick Cheney shot? Are you with me? What liability does Catherine Armstrong hold, or responsibility liability, for the action of her guest? And I said, none whatsoever. I said, Chapter 75 in Texas covered that aspect a long time ago. She had absolutely no liability whatsoever. And I said, thank you. They were looking for an angle, are you with me? And that angle ain't in Texas, because Texas has got representatives and have made this under Chapter 75. But what are the requirements?
Can I ask a question on that?
Yeah.
Let's say you do have two people that are on your land, and the landowner's not involved per se, but they have a land. And those two people, like for our hunting, and one leasing shoots another by accident, then what happens to the person that's shot?
Oh, that's between the two hunters, not between you. If the hunter, if that one hunter was negligent, they would be liable to the other hunter. But you're off the hook. It's on your land, but you're off the hook. It's between those two, not you. There are really three requirements statutory. I think there's a fourth requirement mentally. If you're going to do this, if you're going to do nature tourism with hunters, you need to have some people skills and like people. My father was a farmer and rancher, and he chose that because he liked the solitude. My father would not make it being a nature tourist host, are you listening? And you know people like that. And if you're one of them, don't do it. So I said there's some legal requirements, but there's also some human requirements here. So I said, people have told me that says, I hate the hunters more than I do the hunting. Follow me? I hate the hunters more than I don't mind them coming hunting. I just don't want to deal with it. So I'm saying there is a human aspect here that's got to look at. But if you look at the legal requirements, there's only three legal requirements under Chapter 75, and if you meet them, you automatically qualify. You don't have to do anything else. You're automatically covered. First of all, they have to be there for recreational purposes. And we're going to say this is statutory defined coming up next slide. Has to be on agricultural land. And that is any land outside the city limits. Anything you can grow a crop or a tree on or an animal qualifies. If you have open space valuation or ag exemption, you automatically qualify. So there's never been an issue yet of whether it's agricultural land or not. Anything outside the city or outside the town, probably a lot of land inside the town qualifies. And last of all, please help me. You can't charge more than 20 times the amount of your property taxes, or you need to carry insurance. So let's look at three of these. Let's go look at the agricultural. The statute defines recreational purposes as any of the hunting, fishing, swimming, boating, camping, skiing, picnicking, hiking, pleasure driving, bird watching, cave exploring, or any other activity associated with the enjoyment of outdoors. This statute was passed, as I said earlier, so that landowners would open their land to the public by limiting their liability under this statute. So the whole deal is to protect landowners so they'll open their land to guests. Nature tourism will come under this. Enjoyment outdoors, nature tourism, hunting, fishing, skiing, got water. About anything you think of is a recreational activity that would be covered under Chapter 75. Agricultural land, we say anything outside the city limits, but then it gets a little sticky on how much you can charge. It's interesting. I don't know why they did this, but they say this. They don't say the maximum gross income, net income, it just says charges. If the total annual, on a yearly basis, of all your invitees, remember the invitees are the one paying the bill. So of all of your charges, of all the charges you have levied on your invitees during the year, if they exceed 20 times the amount of your property taxes you paid on the land last year, then you need insurance to be covered under Chapter 75. In other words, you can charge a little, but don't charge a lot. Now, I will kind of hit this real quick. It's what you paid on the land last year. When you paid your property taxes in January of 2010, when you paid them in 2010, January, for which year were you paying? The prior year. So basically, I think what the statute is saying is you take how much your property taxes were on the land you're going to use for recreational purposes in 2010, I paid $1,000 on the whole land. If my property tax were $1,000 on the land I'm using for recreational purposes in 2010, and if my charges on that land exceeds $20,000, 20 times the amount of property tax you paid last year, then you have to have insurance to continue to be covered by Chapter 75. I think that's what it's saying. It's very convoluted language. Up until 2003, they said if you charge more than 4 times the amount you have for taxes, but Texas Wildlife came in and changed it to 20. So Texas Wildlife is on your side. But if you charge more, now here's the question, how much insurance do you need for protection? If you're going to go out and buy an insurance policy to cover your hunters and your recreational guests, how much do you need? Well, it's a good question because most of your insurance agents don't even know this. Chapter 75 says this is the minimum amount of coverage you need. $500,000 for each person, $1 million for each single occurrence. Single occurrence of death or injury, or $100,000 for each single occurrence for property damage. Now, this is the good part here. If you have this insurance, if you charge more than 20 times the amount of property taxes, you're still covered under Chapter 75. You still owe these people no greater dues than you owe trespassers. Second, if you get sued, you don't have to hire an attorney because the insurance company comes in and protects you. But 3, and this is probably the most important one, if you have this insurance, it caps the most they can sue you for. It caps the most they can sue you for. Remember, you got a ranch out here, and you're always worried about the lawsuit. But if you have this insurance, this tells you your maximum amount of liability is the cap on this policy here. So here, I want to throw this out to you. It's something for you to consider. If you have recreational guests on your property, hunter, boater, ski, picnic, and you're not charging more than 20 times out of the ad valorem taxes, you don't need this insurance. But consider this. If you're charging less than 20 times and you have this insurance, guess what? It caps what they can sue you for. So there's a benefit here in this statute is that if I have this insurance, I know the maximum amount of liability I'm going to face from a recreational guest. Now, this is a recreational guest. All those hunting, fishing, swimming, boating, camping, skiing, all that other stuff. So you might want to just consider it. But here's the bad news. There's only 2 places you can buy the policy. Texas Wildlife Association, Texas Farm Bureau. Those are the only 2 carriers of a policy that will comply with Chapter 75. Why? Because of the single occurrence. Most insurance say if it were $1 million for each single occurrence for injury or death, subject to a $25 million cap, are you with me? There would be carriers out there. But because there's no cap on these single occurrences, only 2 entities will even touch the policy. Yes, sir?
In many cases, lease of management for grazing, and many times they lease for grazing and hunting. How does that lease liability trade with it?
Chapter 75 says it covers the lessee, person in possession, and also I think it says and the landowner too. So the question is, if you're the landowner, you're leasing out, do you need the insurance, right?
The question is I don't know.
Right.
And I also lease grazing land from other owners.
Oh, the person in possession.
Lease hunting
think you need some insurance.
I do it. But with this insurance,
I think it cover you, it would cover you for the guests for the, not for the ranching operation, but for the hunting it would. We're listening for recreation purpose.
for the lease land,
For the lease land, right? For the recreational purpose of the lease land. 5 minutes? Let me go for it. That's but my hunters have insurance. What if the people out there are leasing from that? You say, listen, we've got our own insurance, you don't need to get it. You follow me? I don't need to get coverage. I'm the landlord, I'm leasing out, because if they get hurt, they've got their own insurance to cover. Is that a good argument or not? No, it's not, because there's a right of subrogation, just like automobile bill insurance. Your insurance company will cover your injury, and then they will sue the responsible party. It's called a right of subrogation. So I'm just going to hit this real quick. If your insurance pays for the hunter's injury, then they're coming after you anyway. Are you with me? Just because their cover doesn't. So you remember this. If your guests or your hunters have insurance that covers them, make sure you get an endorsement from their insurance carrier that you're an additional insured under their policy. It doesn't cost them any money. So if they get hurt, or you think they'll pay for their hunter's injury, but they can't come after you because you're an insured just like the hunter. So, kind of hit this real quick. If you have kids coming out to your property, and a lot of people open their ranch and farm up to kids, school kids, for an afternoon session, I would say, why do you do that? And they say, well, we have waivers. I'm not going to get into waivers, but I want to tell you this, that a waiver, a hold harmless agreement, will not cover a minor, even if it's signed by the minor's parents. It's case law this effect. So just because you say, well, I have these kids out here, school has insurance and they get a waiver from the parents for the children being out there. You are really up the creek here. One, if the insurance covers them from the school insurance will come after you, are you with me, unless you're an additional insured under policies. So you make sure that if you have children out there, you don't rely on a waiver from the parents, because it's unenforceable. It's void. It has no legal effect. And if you're looking on the insurance from the school covering you if they get hurt, you got to remember the school insurance can then sue you unless you're made additionally insured prior to the time those kids come out there. So something to think about when it comes into the waiver. So waiver hold harmless agreement, real quickly, they are valid. One, as long as it's from a minor. It's from a minor, you get it in an equal market position. You know, they're not open posse. They get something in return. And to make sure that there is one, a hold harmless agreement at the back of your package here. It must specifically say that you're holding you harmless if they're injured from your negligence. If it doesn't have the word negligence in there, it's unenforceable. And last of all, this agreement has to be conspicuously placed to give fair notice to the person signing it. You can't vary from the fine print. So I'm saying if you're seeing this back of your publication here, this is on a separate piece of paper, labeled properly, and they sign this individual thing else. This will cover you for your negligence. It will not cover you for your gross negligence. I don't have time to get in the gross negligence aspect, but that assumption or if that we have also in that will cover you. Now, this is the last thing I want to tell you. I revised the form in the back of that publication just recently. And when I did, I included some things like this. How many of y'all have hunters? How many have waiver agreements? Do they have to sign that waiver agreement every year? See, that's one of the questions. If we got waivers, but how long does it last? And I put in this one, I put in a duration. If they sign this waiver agreement once, it will be good as long as they are permitted now and in the future on your property. But if your hunting lease expired, so does the waiver agreement. It doesn't have to be renewed as long as they have permission to be on your property. But here's what's really important to me. I put a parental responsibility provision in that waiver agreement. Now remember, if you let those kids out there, the only thing that will cover you if there's kids out there is insurance. You can't get a waiver. So I put this one in here, and you'll read it. This is basically what it says. The parents have to sign this on behalf of their minor. Here's what it says though. In return for, this is the parent signing it, the hunter and the recreational kid. In return for allowing me to bring my children onto your property, my minors onto your property, I agree contractually to keep close supervision on them at all times. In other words, as long as they're with the parent, Washington, the traffic nuisance doctrine doesn't apply. It's only the traffic nuisance doctrine there's not accompanied by an adult. So they agree that they will keep close watch and supervision at all times. And then here's what the kicker is. And if my child is injured because of my lack of responsibility or supervision and you get sued, I agree to indemnify you for all costs that you are involved in this. In other words, it's an indemnification. If you let my children onto your land and they get hurt and you get sued, then I agree to reimburse you, are you with me, for any lawsuit brought against you or any judgment or any legal let you're out. So I think this is good. It puts the bear back on the back of the parents, are you with me, to be responsible if they're going to bring those kids out there. So it's something to consider. My time is up, and I appreciate y'all. And hopefully y'all understand your landowner liability issues when you start letting people on your property. I think you should. I think it should be structured properly. And my time.
You'll be around for a little while for questions. If anybody has any questions, he'll be around.